Begin.
Welcome, California. Congratulations on reaching the national finals. It's quite an honor for you to be here, and shows all the hard work that you've been able to do and that what you've accomplished. And so I am Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And you may see me look off to my left from time to time, since there are so many people on this Zoom call. That I have a bigger screen to my left, and so it's easier for me to see people sometimes. So don't think I'm giving you the side eye. That's just I'm going to be looking off to the side there to see the bigger screen. Mr. Volpe.
I am Edward Volpe. I'm an attorney in Denver, Colorado, and I issue my own congratulations to you and to your teacher for your success in getting to the national finals. I look forward to your presentation, but the fact that you are here demonstrates the hard work you have done through 2 semesters with regard to these very important issues. And I salute you for the knowledge that you have gained over this period of time. I look forward to your presentation.
Hi there, my name is Caitlin Johnston. I am an attorney in New York City, and I too would like to extend my congratulations. I was a We the People participant when I was in high school, growing up in Indiana, but I never made it to nationals, so you have already bested me. And I very much look forward to our conversation today. Good luck.
Thank you. Nice to meet you.
Ask the students to introduce themselves and their teacher or teachers as well.
Nice to meet you all. We're Unit 5 from Irvington High School, and my name is Arjun Bothra.
My name is Zachary Martin.
And my name is Archie Detron. We'd like to thank you, the judges, for being here today, and we'd also like to thank our coach, Mr. Martinez, for preparing us.
All right, we are here on Unit 5, question 1. I'm going to read the question at the end. We will start the time for the presentation. A result of the decision in Wisconsin versus Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may begin.
In 1972's Wisconsin v. Yoder, the court was asked whether Amish parents could withdraw their children from school after the 8th grade for religious reasons, reasoning that secondary schooling was unnecessary for the Amish lifestyle and that mandatory attendance would hinder a long-established religious community. The majority of the court fully agreed that the parents' religious rights outweighed keeping children in school. While we support some religious exemptions, we think that the Yoder decision ignored the rights of the child and the importance of education.
First, Yoder gives parents sole discretion in removing their children from school, even though, as Justice Douglas argued in his partial dissent, on this important and vital matter of education, children are entitled to be heard. Second, education was very important then and is even more important now to becoming a self-sufficient member of society at large. With the Yoder exemption, thousands of children have trouble integrating into society economically, civically, and socially, which according to the Amish Heritage Foundation, makes it exceedingly difficult for them to leave their religious institutions even if they wanted to. While many Amish children fully embrace the lifestyle they were born into, others should still be able to access a sufficient education. Even though, as the courts acknowledged in 1973's San Antonio Independent School District versus Rodriguez, education is not a fundamental right in the US Constitution, it is still incredibly important to the functioning society, and the Yoder case undermines that.
While education is not recognized as a fundamental right federally, the 14th Amendment's due process, equal protection, and privileges and immunities clauses have been used to protect the right to an education. The court held the Due Process Clause protects people's right to liberty in 1923's Meyer v. Nebraska, including parents' rights to control the raising and education of their children. The Equal Protection Clause was used to protect the right to an education in 1982's Plyler v. Doe, which barred Texas from withholding education from the children of undocumented immigrants. Some scholars, such as education law expert Derek W. Black, have argued that education is one of the privileges guaranteed by the Privileges and Immunities Clause, as Congress conditioned several states' re-entry into the Union on including a guarantee of education during Reconstruction.
Regardless, education remains a right primarily protected by the states, with all 50 providing for an education system in their constitutions. The guarantees of education clauses vary, with some like Oklahoma's merely providing a system of free public schools, while most others add in qualitative standards for education, like uniform, efficient, and high quality. Furthermore, many states recognize the civic imperative for education, such as California's claim that it is essential to the preservation of the rights and liberties of the people.
The courts frequently attempt to balance the subjectively immense importance of religious liberty with other rights. In 1962's Engel v. Vitale, the court held that the Establishment Clause prevented New York schools from holding voluntary, non-denominational prayer in order to keep religion and public schooling separate. In Employment Division v. Smith, 1990, the court held that Oregon could deny unemployment benefits for religious peyote use, ruling that laws can constitutionally prevent free exercise, provided they serve a rational interest, apply to the general population, and do not specifically target religious rights.
After the passage of the 1993 Religious Freedom Restoration Act, courts have often applied strict scrutiny concerning free exercise, taking a stance to protect religious liberties from interference. In 2020's Roman Catholic Diocese of Brooklyn v. Cuomo, the Supreme Court struck down public health capacity restrictions because they targeted religious activity. While religious liberty is fundamental to freedom, the court must not always grant it priority over other rights, especially the rights of other people. Thank you.
So how should we analyze laws that have an impact on religious beliefs?
I think the best way to analyze laws that have an impact on religious belief is to take the approach the court used in Employment Division versus Smith, where laws that are neutrally applicable to the general population are constitutional if they do not target religious rights in particular, even if they do, in effect, prevent some forms of free exercise. And the reason why I believe we need to take this approach is because if we allow exceptions for every single religious act that violates a given law, then our entire legal system could be removed through these various exceptions if they're required by law.
So the court uses general applicability. I agree with my colleague where the court uses general applicability when dealing with cases of religion. For example, in a 2020 case of S.B. Lanza v. Montana Department of Revenue, the court held that Montana state law violated the free exercise clause, because they barred public funding from going to religious schools while allowing all secular schools from having funding. So that, even though the court was not favoring a religion in any way, but it was trying to make sure that it was universally applicable, that public funding that the state provided goes to all schools regardless of their the religious beliefs or what kind of school it is.
Well, let's talk about that. How has the court basically justified the use of taxpayer money to fund religious schools? And can you give me examples of how that has been upheld?
Well, in some instances, it comes through as a necessity. Recently, in the 2020 COVID relief bill, a lot of money was moved for schools to allow them to reopen and funding for them to reopen. And at the very end, the Senate Majority Leader, Chuck Schumer, added that private schools will also get this funding as well. And be it that most private schools are religiously affiliated, I think that in that instance, the COVID-19 pandemic was something that no school could have really seen coming from the instance. So in that scenario, I do believe that it is okay to allow for that money, to allow for them to continue education.
Well, in the cases my colleagues have mentioned, the courts have used the idea that religion should not be at a disadvantage to other practices in terms of receiving funding and such. I think that in particular, the case my colleague mentioned, Espinoza versus Montana Department of Revenue, reached an incorrect conclusion in determining that school vouchers should be able to be used at all schools, even if they are private religious schools. I disagree with this decision and agree with the 4 dissenters in that case because it violated the previous precedent set in Locke v. Davey 2004, where Washington was allowed to prevent scholarship funds from funding theological scholarships. And I think that this is the correct approach, because while the government should not be actively discriminating against religion, it does not have to support religion equally to all other practices, because religion is different from other practices, and the government can act on that difference and treat it in a distinct way in some circumstances.
So you said that you disagree with the Yoder decision, that it was wrong, that parents shouldn't be the only ones to have a say. How should we balance the child's rights against the parents, and when should the government intervene, and how? And I'd like to give you a hypothetical. Let's take it out of education and go to a religious sect that marries their young girls before they're 18 and compels them to start having kids. How would you deal with that? How do you weigh the interests of the child and the parent?
Well, I think in that instance, when you're talking about that's a problem of consent and at what age consent can be given for the child. I think the government has a right to go out of its way to make sure that consent age is proper. In a case like Prince versus Massachusetts in 1940, the court basically says that when the child's welfare is in question, the government can have a say as to what they would do. So I think in that instance, making the consent at around 18 would be a reasonable interest and is accepted by a good majority of the population as a whole.
So I think in that hypothetical, which you're referring to, I think there really has been no precedent or which says that which would allow religious belief to take hold over that and allow that to happen. So I think that's why, I mean, in many states, the age of consent is at least 18 years old, and given a lot of time, this could be forced. The government should, in such sensitive situations, the government should be able to intervene and have discretion when it comes for a young child marrying someone, or young child marrying someone and giving consent at a non-legal age.
I think the core issue here is the two considerations at hand: the parents' religious or other rights, and then also the child's rights. And I believe this is what Justice Douglas was really contesting the majority opinion with his partial dissent. He thought that because children are very involved in their own lives with their own education, and in your example, with their own marriage, their interests are very significant and should not just be ignored, and they should not just be subject to their parents' guardianship in all circumstances. And the government should be able to intervene to protect those children's interests in the likely case that they do not fully consent to marriage or dropping out of school.
Can a school lawfully require that a student be vaccinated against the coronavirus against a parent's religious beliefs before being allowed to return to school?
In the 1905 case Jacobson versus Massachusetts, the Supreme Court held that forcing people to have a vaccination, in this case a smallpox vaccination, was part of the police powers of the state and something that they could enforce on individuals regardless of their protests, because it related to the health and safety of the general population. And I believe the same should apply in a public school, unless there's a medical interest that makes having a vaccine dangerous for that student.
I think that in cases of public health threats such as smallpox or COVID-19, I think the government has extreme interest to be able to protect its students, protect the general population. So public school districts such as Seattle, which mandated vaccines 2 years ago for all students entering, I think it is a necessity, and unless there's any kind of medical reason, no religious belief should be able to interfere with that, and they can compel those enrolling to get a vaccine.
Well, you're talking about the regulation of schools with regard to the current pandemic. May a state limit the number of people who may gather in-home religious meetings in this pandemic era?
You're on mute, Edmund. You got cut off by the bell.
Sorry, I'm
Mr.
sorry,
Volpe, I
guys.
think
We are out of time.
we run out of
Well,
time.
I'm sure your answer to that question would have been wonderful, and I'll score you accordingly.
All right. Well, everybody take a deep breath. You did very, very well. You should be proud of yourselves. Your teachers should be proud of you. You were great. I was impressed with the breadth of cases that you discussed in your initial presentation, and even more so with the cases that you came up with the questions that we asked you. Some of the questions were a little bit out of left field, and you were able to pull out some pertinent and appropriate citations to cases. So that was very well done. I like the way you shared the workload, and everybody equally spoke and expressed your thoughts. And I really appreciated your presentation, and congratulations. It was very well done.
I certainly agree with the comments of Judge Murphy. The fact that you were able to come up with so many cases in response to the questions we were asking you tells me that you have a wealth of knowledge with regard to Supreme Court cases, Prince v. Massachusetts and Jacobson versus Massachusetts, and coming up with a thorough understanding of Douglas dissent in Wisconsin v. Yoder, I thought was excellent. Your reference to privileges and immunities in the 14th Amendment, I thought was very, very interesting. I haven't heard that before. If you want to study the P&I clauses, you want to get familiar with the slaughterhouse cases. You came up with Plyler v. Doe with regard to the fact that students cannot be barred based upon their status as illegal aliens. And you came up with Engel v. Vitale with regard to no organized prayer in schools. There are a number of cases that address that similar issue. You came up with Employment Division versus Smith on the use of peyote. You should understand that the use of peyote was subsequently approved for religious ceremonies in the Gonzalez versus O Centro case, which said that given the fact that Native Americans have used peyote in their religious ceremonies for centuries, it is an improper imposition upon them with regard to banning the use of peyote. That, of course, was after the passage of the Religious Freedom Restoration Act by Congress, and that had an influence on the case decision. The Espinoza case versus Montana Department of Revenue, I thought was excellent. You did demonstrate an understanding of RFRA, the Religious Freedom Restoration Act, and you went on to talk about the provisions of your Colorado Constitution. I think that is very important knowledge, given the fact that virtually every state constitution addresses the right to an education. It may not exist expressly in the federal Constitution, but I can't think of any states that don't address education in their state constitution. Congratulations upon your demonstration of that knowledge. Congratulations to your teacher as well.
I echo those congratulations. I thought the prepared remarks were wonderful. You took a position. It was very concise, that you were hitting all of the different prompts, but you did so in a way that really flowed together well. And this is a stylistic point, but all of you were very measured and clear in your delivery, both in the prepared remarks, which often get like bulldozed through because you're trying to cram a bunch in, and it's actually very hard to follow. But you did a great job of measuring your delivery, and that carried through to the follow-up questions. You just like oozed confidence on the follow-ups and the back and forth. So substantively, I thought it was excellent. My question was one of the oddball questions, and I really like how you dealt with it. There are, I think, only 4 states with laws on the books that protect children from having their parents wed them. after under the age of 18, and this actually is a fight among certain religious sects that do this. So I just wanted to see how you would deal with it, and I thought you did an excellent job to kind of bring in the consent piece, and your analysis of that. You did an excellent job with kind of a curveball question. So I really enjoyed our discussion. Congratulations.
Thank you all. Yes.
Thank you.